Part 3 on Florida trusts and the responsibilities of trustees and the rights of beneficiaries under trusts. The most important thing both parties have to understand, the trustee that's managing a Florida trust and the beneficiaries, the qualified beneficiaries under a trust, is the broad concept of adequate disclosure. One of the most frequent calls that I get in here is from a beneficiary who says that the trustee is not adequately disclosing. What the term adequately disclosing means is crystal clear. It comes to us in statute. The Florida statute, the law, describes very clearly what adequate disclosure is, and trustees had better be paying careful attention to this. Now, little practice pointer for the trustee: this is a burden, this is an obligation, and don't take it lightly, and don't be afraid to spend trust money to do it correctly, because if you don't, you may find yourself subject to a lawsuit because what I'm going to describe here. In this video, we're going to talk about what the statute says about what is adequate trust accounting, and it's going to alert both sides of this equation, trustee and beneficiaries, qualified beneficiaries, as to what your duties and obligations are. All this law is found in Florida Statute 736. It's the trust code. Trust code lays out exactly what it is, and little trick here for both of you, AI does a real good job of explaining what this is in real clear terms, and we'll even provide you a little checkbox there that, frankly, I encourage people to use when you call in. If you've educated yourself with AI and you know what these answers are, it really helps me in doing my analysis. But the bottom line is this. Brother dies, he's made you the trustee, you got real specific responsibilities at the front end, adequate disclosure at the front about what's in this trust so that the qualified beneficiaries can begin to understand. What are those accountings? You got to do those things annually. You got to do it whenever a trustee changes, and the statute specifies exactly what those requirements are. Assets at the beginning, assets at the end, where are they held? Better be held in a responsible place, because you could get hit with a breach of fiduciary duty if you're the trustee when not doing so. There are accountants that specialize in this. Particularly with bigger trusts, this is not a job for bookkeepers or, these people just kind of manage money. No, we're relying upon a certified public accountant that has a license, that has professional responsibilities, that knows what they're doing. Over and over again, I say this in my practice: I do not do numbers. I don't even touch the documents at the front end. All that goes to a certified public accountant. They track down all the accounts. They plug in all those numbers. Then we sit down and we grind those numbers together. But I rely upon the expertise of a certified public accountant. Has my trustee sitting right there. We're asking the questions to the certified public accountant, and we rely upon that information independently. But the specific topic of this video is what do you do if you're a beneficiary and you have questions about what's happening to your money? If you're a qualified beneficiary, it ain't the trustee's money, it's your money. That trustee is acting in a fiduciary capacity. Generally, there's a 6-month window for you as the qualified beneficiary to challenge whatever information is being provided by the trustee. That 6-month window could begin to run from the moment like an initial disclosure is made. If trustees disclose that dad left the trust with $2 million and lo and behold, you think it should have been $3 million, your clock to start challenging that could begin at that initial window opening. There are two very specific cases out here that deal with this, and bluntly, that's one of the fascinating things about all this trust stuff, is the idea that there's a pretty small universe of cases that deal with trust accounting. There's millions of dollars flowing around, hundreds of millions of dollars in the trust world in the state of Florida, and very few cases that deal with that. But the one case that starts this thing off, Turkish v. Brody, I'll drop in a link here in the description section, 5th District case. And that alerts us, hey, beneficiaries, you get something in writing. It's a certified mail, could be email, but you're on notice of something, and that triggers your obligation to start thinking about this and moving something within 6 months. Don't wait 7 months. Don't wait 8 months. Don't keep jawboning your uncle, the trustee, whatever, and saying, hey, I question this. No, boom, 6 months. Make that filing. Do something about that. Get a lawyer. You don't even have to get a lawyer. Do it yourself, though, but at least make that statute of limitations problem go away. Second case, Correa versus Sanders. This thing really was sort of a boom nuclear bomb because it really set to overturn a lot of the things that we held. But the bottom line in Correa establishes the proposition that it's actual knowledge of the qualified beneficiary. You get knowledge that something's not right, you got a duty to act right away. And the lesson in Correa was reasonable diligence as part of the deadline calculation. You can't just think something's wrong, sit on your hands, and then, a year later or whatever, 2 years later, say, "Uncle, I got a problem." No, court could shut you out and say, "Too bad, too sad." But let's talk about how all this works together. Again, oftentimes the call comes in, uncle died, grandmom died, whatever, established the trust. They trusted the trusted grandkid or kid or whatever else like that. And they're doing their best to manage this thing. Even if they're acting with complete diligence and responsibility, honestly and ethically, and not blowing money, not doing stupid stuff, if they don't account properly, you risk getting sued by one of these qualified beneficiaries over here. Again, even in the circumstance where you're doing everything right. Let's talk about the circumstances where the trustee kind of either goes rogue or just kind of makes some poor judgment choices. You're the trustee. It's got a couple $1 million in it. You're doing what dad, granddad, whatever thought you wanted for this qualified beneficiary class over here. And then you start writing yourself some checks that are bigger than what should be. Maybe you as the trustee start getting pissed off because this one qualified beneficiary over here is a pain in your ass. He's making demands of you. He's always asking about the money. He's just really getting on your nerves. And you decide that this guy's going to be punished for that. And you're going to start taking out of what he's entitled to a little bit more money as a punishment or a fee as a consequence for asking questions. Bad news. Don't do it. Get a lawyer. Understand what the rules are. There's a way to deal with the black sheep guy asking the questions. That is, provide the information that he's looking for, provide a schedule about what he's getting, when he's getting it, and do that as a way to protect yourself. Again, if you're the trustee and you got a squawky little qualified beneficiary over here that, again, is a pain in the ass, get an attorney and make sure that you're dealing with this squawky one over here in an appropriate way. But the bottom line is this. Florida statute provides very clear rules. It blows my mind, frankly, the number of times I see these cases where it's a trust with a significant amount of money and the trustee over here is being cheap with spending the amount of money that's necessary for that trustee to do their job properly. And that means hiring CPAs, hiring lawyers to do it properly. What you are doing, Mr. Trustee, Ms. Trustee, if you are not hiring proper professionals to represent you, is you are setting yourself up for a lawsuit in which you're going to be accused of breach of fiduciary duty. Could be fraud. That's a nasty lawsuit to be involved in, even if you think you're doing everything right. Again, if your brother, if your dad or whatever made you the trustee, don't do it unless you can pay and you're willing to pay the proper amount of money to get proper legal advice. I'm going to provide a list here, a sort of a topic seminar with all this information, a guideline for trustees. It's the one we provide to our clients. It provides the checkbox and the information that you need to make sure you're protecting yourself and doing your job properly as a trustee.